It is time to make a start. We have attained the quorum. I now call to order the Bills Committee on Occupational Retirement Schemes Amendment Bill 2019. According to the agenda, this is election of chairman. We're electing the chairman of this Bills Committee. In accordance with the House rules, I now invite a nomination of chairmanship. We need to have a member nominating the member, seconded by another member, and the member being nominated should accept the nomination. I nominate Mr. Christopher Zhang, Mr. Ronick Chen, and Mr. Chen Bo second. Mr. Zhang, you accept the nomination? Yes. By the count of 5, pending other nominations. 1, 2, 3, 4, 5. Okay then. Any comments? No, I thought you were going to make some nominations. All right, we don't have any further nomination. Congratulations, Mr. Zhang. Thank you very much for your support. Do we need to have a deputy chairman? Dr. K.K. Kwok, I wish to make nomination Mr. Kenneth Leung. Right? Any seconder? Mr. Felix Jones seconds. Any further nomination for the vice chairmanship? Mr. Leung, to accept the nomination? Yes, I do. Any other nominations, please? No? I declare that Mr. Kenneth Leung be the Vice Chairman of the Bills Committee. This is shown on the board. Shall we invite the administration in, please? With us for today's meeting, Mr. Eddie Zhang, Deputy Secretary for Financial Services and the Treasury, Ms. Zhong Hong, Principal Assistant Secretary, Ms. Gabriella Yi, Executive Director of MPFA, Ms. Maria Chung, Senior Manager. Mr. Eddie Zhang, will you please brief us on the details of the bill? Good morning, Chairman, members. This is about the Occupational Retirement Schemes Amendment Bill 2019. First off, the purpose of the amendment. Do we need to have a look at the board or the screen? Right, let me carry on. The purpose of the bill is to update to make sure that it's not used as or misused as an investment tool, because this is supposed to be an employment-based kind of scheme, and employees not of the relevant employers of the scheme should not be taking part. Now, the idea is to enhance the registrar's power to make sure that this is an employment-based criterion. I'm going to go into further detail about the definition of employment-based criterion. Second, to enhance the governance of the also schemes. By way of background, the also schemes predated the MPF. Back in 1993, we had the registration system to make sure that the schemes will be properly managed and there will be no default, in other words. And the contributions to these registered also schemes will enjoy tax concessions. Under the ordinance, there are two types of schemes. The first one is the properly registered scheme. The second one is the exempted scheme. And for these exempted schemes, there are two reasons for the exemption. First, to put it simply, these are offshore schemes. The definition is they are approved by authority outside Hong Kong, like some U.S. employees. They have taken part in the 401k scheme. They are in Hong Kong. We make sure that if there are any problems, they can file legal proceedings to get what they're entitled to. These are what we call the offshore registered schemes. Second, there are many people who are not Hong Kong permanent residents. Now, the definition is that it should not be more than 10% or 15 members who are Hong Kong permanent residents. There are some airline companies that have crew members who are of different nationalities, and that would fall under these schemes. In the year 2000, when the MPF was introduced, there was a one-off measure for those also schemes that have already been registered. They will enjoy exemption. Once they're exempted, the members do not have to take part in the MPF scheme. Second, even if they're not exempted, the members have to take part in the MPF, but these companies can offer, on top of the MPF, another layer of protection with the top-up schemes. It would be easier to understand if we call it top-up schemes. Some statistics now for registered schemes and exempt schemes. There are 4,132, 3,200 exempt schemes, 932 they have not been exempted. For the past 3 years, as you can see from the figures there, 2016, 30, 2017, 12, 2018, 24, and these are the new also schemes. The problem is that some of the also schemes are misused as collective investment scheme. Anybody can take part, and this is flying in the face of the original intent, and that would fall outside the regulatory ambit of the SFO, and they can escape the regulatory provisions of the law. Now, this is subject to misuse because at the moment the requirement is pretty lax. The application threshold is very low. We're not clear about the causes that can be cited for withdrawal, and this is subject to certain abuse. Now, there is an important concept that we should have the employment-based criterion. We want to limit the members to employees of the relevant employers of the schemes. At the moment, the provisions are not sufficiently clear, and they're open to interpretation. Second, they can be bona fide business transaction between two schemes, and they can be transferred. Say, for instance, for mergers, the employees will be transferred from one scheme to another. Third, the estate beneficiaries of the deceased members. Let's say the member has passed away and he may not be collecting the accrued benefits, and the beneficiary of the estate would like to leave the investment there for some more years, and this is only right and lawful that this be allowed. Now, this is a simple chart to show members what the amendments are all about. To the left is the requirement under the registered scheme, and after registration, what they are supposed to do to achieve compliance. On the right-hand side, they're referring to the offshore schemes, the exempted schemes. The red bits are the what we added. When they make application for registration, the applicant or the sponsor or the employer is supposed to submit statements from lawyers and auditors as well as actuaries. The actuaries' certificate means that they cover the defined benefit schemes. It's like pension schemes. The actuaries will have to make sure that there will be sufficient funding to go around because people are living ever longer. And these will not be quite sufficient. We want to specify in the employer's statement that they do have the employment relationship. The auditors will also need to issue the statement that there is the employment relationship. Now, this is completely new. The employers will also need to file a declaration that they're covering their own employees only. Once registration has taken place, each year the employers, that is on an annual basis, submit an annual declaration because there are changes to the personnel and they have to file these declaration every year. For the trustees, all the these should be added to all the requirements. For the exempted schemes, there will not be any reason. There will not be any practice for exemption based on the small number of permanent Hong Kong residents. Second, even for the offshore schemes, we need a declaration from the employers. Each year, the employer will need to issue a statement to prove that there is the employee relationship, and there is the annual declaration as well. If members have any questions about these, we are happy to answer them. We have consulted the sector, the Law Society, the Institute of Accountants, and they have contributed their views, and they are happy with the compliance requirements. I don't propose to go over this regarding the new application for registration and exemption, except to say that there is a specific provision that if there is a contravention of the employment-based criterion, the registrar can withdraw or cancel the registration or the exemption certificate. This is the table summarizing what I said. I don't propose to repeat it. Other than the fundamental points, we are going to add the provisions to enhance the registrar's investigation and governance power.
Actually similar to the requirements under the MPF ordinance, so they are comparable. If the registrar thinks that there is non-compliance with requirements, he can apply to the court for the freezing of the assets in order to protect the interests of the employees, because there's a danger that he might abscond with the money belonging to the members. So we've also proposed to amend some of the terminologies and streamline some of the procedures. These are the proposed amendments after taking into consideration the inputs from the employers. Regarding the responsibilities of the trustees, again we are making proposals to further perfect those responsibilities. So with that, I will stop here, and I welcome questions from members. Do the other officials like to further supplement? If not, I'd like to thank Mr. Cheung, the Deputy Secretary, for his detailed presentation. For members who would like to speak, may I propose that each member be given 4 minutes. Mr. Leung Kai Cheung, Kenneth Leung. Thank you. I'd like to go back to the 5th slide, and you've given us the numbers here that there are altogether 4,132 also schemes, of which the MPF exempted schemes was 376, and for the non-exempted also scheme, the number is 932. Is it that the contributions for the non-exempted schemes, will they also be entitled to a tax deduction up to 15% of the salaries of the employee? Ms. Hong? If the employee were to make the contribution, then he is entitled to a 15% up to deduction. Now, according to if the proposed amendments were approved, there have been some also schemes set up in the last few years. Some of the members may not satisfy the genuinely employment-based criteria. Does it mean that these members will have to immediately quit the also scheme? So what is the arrangement? Monsieur Chairman. Ms. Yu from the MPFA. I'd like to thank Mr. Young for the question. If the scheme, now after the bill became law, for the members who are not employees, then they will not satisfy the requirements in respect of the also schemes. Then we will then approach the parties concerned. The also scheme should be employment based, and if there are other people joining the scheme, so we would. I think the also scheme can still be maintained, and the employees can still join. But what about the former employees? So would they be covered? They're not existing employees, but they were former employees. Would they also be covered? I think the former employees will also be covered. Like Mr. Cheung said, if they are not employees of the same company, except that they've joined the scheme after the merger of a company, then the old employees of the company will still be, covered. So in other words, because of a merger or acquisition, well, sometimes you may have companies which split up, or employees of a company which have been hived off would they still be allowed to stay, in the scheme? You may have some old members who can they still remain on the also scheme. There was previously an employer-employee relationship. Yes, Chairman, I don't think I have too much time. Now, perhaps I'll ask one more question. Now, somebody, well, but there's a situation where there seems to be or there seems not to be an employment relationship. Who then is to decide? Now, if there is a consultancy arrangement, there's a consultancy contract, and that person seems to be an employee and at the same time may not appear to be like an employee. Now, eventually, how would you decide whether or not there is a genuine employment relationship? Do you need other professionals to bear that ultimate responsibility? Of course, the lawyer will issue a certificate, so would the auditor. The employer will also issue a certificate. Eventually, who would bear the ultimate responsibility to decide whether or not there is a genuine employment relationship? Now, regarding the role of a contractor, I think the ordinance already takes care of that. That is, if somebody were a consultant, but he's being, I think if he is regarded as part of the organization, we would deem that there is already an employment relationship. So this is how we interpret the ordinance. Mr. Chen Chen-ying. Thank you. I saw the purpose of the bill, as we've read from the paper, is that there are some also schemes which have been misused. So my question for Mr. Cheung and the administration is this. I noticed that there are many such cases on page 9, the so-called exempted schemes, and the 590 non-exempt schemes. What exactly is the distribution? If we know, if we know which of the schemes is a more has a more serious problem, then perhaps we can focus on attention on those. And secondly, I am also worried that at the time of application, the company, produce some fake employment contract which will be terminated after registration. Mr. Chang was asking what would be regarded as employment relationship, even if there is an employment relationship, but after the scheme is registered, the contract is terminated. Here you are saying that you require the professionals to provide evidence, but the registrar can also discover such abuses in the course of inspection. So before it's being discovered upon investigation, then would it mean that the registrar will freeze the registration, or is that there's nothing that could be done? If the MPFA now suspect that there are now 8 such cases which are in breach of the rules, and I think roughly about 550 people which have been involved. As to how many of them really do not have an employment relationship, I think we need to verify and investigate into that. Secondly, why is it that we need to propose the power to conduct inspection? Because we need to obtain the evidence. Our objective is that we adopt a reasonable man test to so we need to. So if somebody simply sign a piece of paper and there's no details at all, so one would therefore has to doubt whether or not there is a genuine employment relationship, in which case we can take action. Regarding the cancellation of the scheme, it would depend on the circumstances. An extreme example would be that the majority of the members are not genuine, are not members. They just sign a piece of paper and pretend to be employees. In this case, we may have to cancel the registration. But if there is only, say, one such, person, it could be simply, oversight or negligence. And the employee who is not eligible will have to withdraw from the scheme. So these are the scenarios that we have envisaged. Mr. Chinkin Paul, thank you. The PS said that you've already consulted the insurance industry. I'd like to ask whether or not they've raised any questions, and also after these proposed changes, would it affect the normal course of business? Have they relayed any concerns to you, and have you made any concessions, and have you plugged any loopholes so that you will not affect the normal business operations of the insurance industry? Thank you. It may not just be the insurance industry. For these registered schemes, it may also involve the trustees, and they've not reflected to us any problems. Instead, we've received some suggestions from the employer association. They like the MPFA to provide more convenience. For example, some offshore schemes, where they are registered, in a jurisdiction, they hope that they could be exempted. They would like us to notify them which are the countries and regulators. I think if the schemes are registered in those jurisdictions, then they would be exempted. And we've accepted that suggestion, and that's why we've prepared a table. I don't know whether Ms. Yu would like to supplement. Yes, for the employer association. Now, basically, the also schemes have been set up voluntarily by the employers for their employees. So we've approached the employer association and the representatives. Their main concern is that in future, if we were to cancel those schemes with only a small number of Hong Kong residents, how do we deal with that problem? And their demand is that if we think that if there are some overseas jurisdictions or regulators with similar functions like our MPFA, they would like to be informed first. And we've already done that, and we've already supplied them with a table telling them about comparable regulators in other jurisdictions similar to the MPFA. So you've already consulted the employer groups, insurance industry, and so on, and there has not been any objection, right? Any further views from members, or anyone who would like to go for the second round? Kenneth Leung. Thank you. I'd like to follow up on my earlier question regarding the continuous employment relationship. So now if somebody has worked for the employer for 1 month, and then the employment relationship is terminated, and another person works for a year before the relationship is terminated. So what do you mean by continuous? When you answered my question, you said that former employees can also benefit so long as they had once had an employment relationship, then they can stay within the also scheme. I think that's a major benefit because there is at least a 15% deduction, and it's also continuous. Secondly, if there is no longer a continuous employment relationship, but the person is still an also scheme member, he might have joined another company. Is it possible that you can that this person can get the 15% tax deduction from different ORSO schemes. Originally, he was a member of ORSO Scheme A. Of course, he's entitled to the deduction, and he, then worked for company B. Of course, I'm talking about the tax deduction that the employer will enjoy. But for the employee, he is only entitled to one, deduction, right?
Yes, we address the issue of continuous employment relationship. Yes, this continuous employment relationship, as Mr. Eddie Chung said, this has to be a genuine relationship. As to how long after the termination of the relationship can one stay in the scheme, it would be stated. Pension scheme, there would be continuous payment until the death of the person. So the fact that he has left the company doesn't mean that the relationship will end. So there is a provision like this here. If you say that this is a fake arrangement, and upon investigation the whole thing has been uncovered as fake, then we will take action accordingly. We would receive inquiries from time to time as to whether someone can join the ORSO scheme based on the relationship. We would explain to them that there has to be an employment-based criterion. The fact that someone enters into some agreement verbally or in writing doesn't mean that he's a member. Mr. Leung. Now, for the employment relationship, there is a simple definition. If you apply the common law test, would it be the same test as we would apply under the employment ordinance? Yes. Any further points? Are you going to proceed with the clause by clause? If I may put a few more questions, still early. Now, for these also schemes, as a result of the amendment, I understand that FATCA, under the U.S. FATCA, some of the collective investment scheme, you have to make declaration. That's under the OECD tax information exchange. If someone has joined the collective investment scheme, that is, it's a little bit confusing because there is exemption under also. So in this tax information exchange, if there are tax residents who have taken part in the also scheme in line with the employment relationship, and if there is a U.S. resident who has taken part in also scheme, Chairman, a bit complicated, beg your pardon, under the also scheme, under these two regimes, what will be the reporting requirements for the trustees under these two different regimes? Chairman, there will be no exemptions. That's my simple answer to that. Any further questions? Yes, I do, Chairman. Mr. Chen Kim-bo asked a question, and you said in answer that there has been a round of consultation on the trade. Is it the case that the employers are more concerned because of the additional administrative work? Did they express more concerns, the employers? Madam Hong? The employers' concerns are not so much the additional administrative work, because we just require them to file annual declaration and let us know about the compliance requirements, and that the employers are working for the company. That doesn't really add to the administrative burden. As I said, from the employer's point of view, they hope that they would be able to absorb some foreign talents, and they are concerned that if they want to bring in talents from outside of Hong Kong to assist in certain projects that require specific expertise, and these people have taken part in a retirement scheme overseas, and because of this change, it would be hard for them to enjoy the exemption, and it would be difficult for them to recruit from this field, and this would impede their development, and this is their concern. Chairman, I understand that. Now you mentioned the territorial list for exemption. How soon are you going to be able to come up with that? We have posted that on the web, and that's not part of this bill, is it? No, it's not part of this bill, because we are giving guidance to the trade for them to assist them in making the application. For other territories, we are happy to discuss whether the authorities there are fulfilling similar function. How many jurisdictions fulfill the exemption criteria? Can you cite us some examples, please? We are looking at the applications that we received. There are 5 jurisdictions: US, UK, Canada, Singapore, and Taiwan. In the light of the applications that we've received, whether they use the overseas regulator or the number of members as the basis for application, we have covered all of them. Right, let me get in a minor question here. Madam Hong has already alluded to that. Has the government assessed, as a result of the amendment, whether this would affect people's desire to come to Hong Kong? You mentioned the specific talents. Would there be any implications on this? Have you also consulted the chambers, overseas chambers? Yes, indeed, we have consulted the foreign chambers. Regarding, in particular, the exemption arrangement, in the light of their concerns, we have amended the proposal. If they have a registration overseas, they will enjoy the exemption, and the chambers find this acceptable, and they didn't pursue with the issue. Unless members have any further questions, shall we move on to the next item, and that is the clause-by-clause scrutiny of the bill. Chairman, I defer to Madam Hong to take members through the clause-by-clause. CB1 1061 stroke 1819 bracket 01. We work on the basis of the Chinese version, perhaps. Page 1. We have deleted the definition of member. This has been moved to eligible person, but this is a new definition. I'll go into further detail when we come to that. The next page. We've taken away existing as a definition. Back in 1993, we had to deal with the transitional arrangement, the schemes that were in existence. So there was no need for that, and we are deleting this definition existing. Next, Occupational Retirement Scheme. This is an important amendment. And this we have clause added by its terms limits membership of the scheme to eligible persons. Page 3. Eligible person, there is a new definition, and this will be covered in Section 2A. We have 3 additional new definitions. Existing scheme, and this is not the same as existing. That one referred to before 1993. Here, it means an occupational retirement scheme existing at the time when application is made. We've also added authorized person and investigator. Page 4, we add a new 2A, a meaning of eligible person. An eligible person is an individual who has an employment relationship and a transfer agreement. We have covered this. Transfer agreement refers to merger and restructuring, and also the beneficiaries of the estate. And next page, interpretation of employment. That's in the original version. We've singled this out to deal with issues like people serving as advisors and consultants for more than 4 years, and they will be, if they are regarded as an integral part of the business, we deem that as an employment relationship, even though there is no contract. And also the non-profit making organization and the retirement protection in other countries will not be governed by this bill. And these has always been in the ordinance. We just single this out. Our legal advisor has got a question. 2B, Chairman, bracket 2. If a person provides service on a full-time basis to a business or other organization for more than 4 years, does it have to be a continuous 4 years? Or does it have to be, or can it be an intermittent 4 years, or what? It has to be solidly continuous 4 years. Please. Page 7. As we said, we've moved the provision to the earlier portion. Now we have added a provision to refer to the final disposal of the case. Now that's when a registrar has accepted an application or the appeal period has come to an end. That's to make the provision clearer. Page 8, we've added a provision to authorize the registrar to issue guidelines. There is certain information and documents that have to be provided to the registrar. Now, page 9, subclause 8, on top of page 9, a person does not incur a civil or criminal liability only because the person has contravened a guideline. And the court can take compliance as evidence in other financial institutions' ordinance. This has appeared before. Mr. Kenneth Low, you've got a question. Yes, Chairman. 6A, about the guidelines. I am surprised why the registrar didn't have any authority to issue guidelines in the past. Is that right? The registrar is in effect the MPFA. For this also scheme, didn't you have the power to issue any guidelines? Is it correct? Yes, the MPFA for the applications, or dealing with applications, would issue some guidelines to assist the applicants or the employers to deal with their schemes. The amendment to this provision is that the guidelines issued under 6A can be adduced in court to use it as evidence whether there is compliance with the guidelines. So this will be adduced as evidence.
I noticed that in 6A bracket 2A, it says
a code standard specification or provision。咁你哋嗰啲指引係咪得？
So is it that you only have one type of guideline? You use terms like code, standards, and specifications. So for these several adjectives, so in terms of compliance, are they different in any way? Is it that code means that you have to comply? There is mandatory compliance or what? I just want to know, whether there's only a single guideline. Overall, there is one type of guideline, but specifications means that pursuant to a particular provision, we need to, designate certain things. For example, we have to designate what the annual return should include. That would be a specification. Standard means that these are the rules that we want them to comply with. So basically, we're talking about different documents, but they're all guidelines, and the effect will be the same. So for these three different terms, legally speaking, if they were used as evidence, it would be the same. Yes. Carry on. I think we've covered page 9. We're now on to page 10, which is exemption. On page 10, the triangle at the bottom there, we've added a new provision, a written statement by the relevant employer and representative employer that the scheme by its terms limits membership of the scheme to eligible persons only. On page 11, the original subsection 4 lays down the conditions for exemption, namely that the scheme would have to be registered in another jurisdiction, or that there are no more than a given number of members who hold Hong Kong ID cards. We've added a new 5 capital A. We've taken away the criteria, stipulating that the scheme should not contain a given number of members. 5D says that the registrar could, when issuing an exemption certificate, may impose certain conditions, but in doing so, it has to give the employer prior notice, and that the employer should be given a chance to make a written submission. Page 12. The decision for the registrar to impose conditions that could be subject to appeal. Page 13. For exempted schemes, once exemption is given, then if there is any change we've changed the conditions. We do not allow someone with an employment relationship to join the scheme. We would like the scheme to stay an exempted scheme, so that the registrar can take enforcement action pursuant to this ordinance. In 1B, the term that is that he can allow someone who doesn't have an employment relationship to join the scheme will become void. So this would affect the schemes with exemption certificates. Subsection 3 will lay down the relevant penalties. Page 14. The amendment, the triangle, Mr. Kenneth Leung. For the exempt schemes, you say many of them are not registered in Hong Kong. These are offshore schemes. How are you going to take enforcement action? The exempted schemes, they still have some members. Then how are you going to take enforcement action? Well, as usual, the scheme would have a representative in Hong Kong, because if they are registered in Hong Kong, they would have some members who are Hong Kong residents. So we will still be able to approach the agent, either the administrator or the employer or the employee, and we can still conduct investigation and take action. All right, we're on to page 14, the triangle. The registrar may, by written notice, require the person to submit certain information. So instead of just requiring the employer, we can require anyone only the information to provide the information. The subclause below, we've added the requirement that the registrar may, by written notice, require the person to provide any information or document. So that the registrar can decide whether or not to allow, anyone to join the scheme. Page 15 requires the employer to provide an annual return and a written, statement. And we hope that the employer can stipulate that under the scheme, all the members are eligible persons. Page 16. These are some consequential amendments. The last one, reasonable excuse, is only, textual, amendment. Page 17. The original section 11 is proposal to withdraw an exemption certificate. If the registrar finds that certain exemptions have breached the rule, then he can propose that the exemption certificate be revoked. And we've added some further grounds. Or, for example, the condition imposed by the registrar earlier had not been complied with, or that the requirement to provide information and so on had not been complied with, or that the scheme does not contain all members who are eligible members. And finally, that the exemption should be in the public interest, and in which case the registrar can revoke the exemption. I'd like to go back to section 11. That is the condition involving public interest. In considering whether or not it is compatible with public interest, what factors would you take into consideration to decide whether or not the revocation of the exemption is in the public interest? Now, in certain schemes, a scheme may already be widely publicized in overseas, saying that it's a scam, or some overseas government have already taken certain actions against that scheme. In this case, we can invoke public interest and make a corresponding proposal in Hong Kong to revoke that scheme. Page 18, the amendment indicated by the triangle. That is, we want to propose to streamline the proposal in respect of the cancellation of the exemption. That is, the notice containing the proposal in a way the registrar considers appropriate. Page 19, we have some textual amendments here. The triangle represents another textual amendment. The penalty would be the same. Page 20. From sections 12 to 14 is about provisions regarding withdrawals of exemption certificates. They are the same as section 11. To save time, and if there's no objection, I will not repeat that here. It's all the same, except that the procedure has to be, complied with twice. Page 24. This is about the registration of the schemes. There is an amendment. That is, the requirement that the So we've added the requirement that registrar has to consider whether or not accepting the scheme is in violation of public interest. So it's a consequential amendment. Page 25, we've added subsection E. That registering the scheme is not contrary to the public interest. That would be the consideration the registrar has to make. 26, 27. These are consequential amendments. Page 28, we added the subsection, that is regarding any registering application, the registrar may impose conditions, namely that the employer should be given a notice and that the employer should be allowed to make a written submission. And also that decision regarding the definition, we've also provided for, grounds for appeal. Next, we may turn to page 32. Originally, actually, this is in respect of section 20. That is, a registered scheme would need to keep certain accounts. We've added subsection 3A here to stipulate that the financial transactions of a registered scheme, including transactions involving the transfer of benefits to and from the scheme, and that must be included. This will further clarify the provision so that the registrar will know about the financial transactions of the scheme. So this is again an arrangement to protect the interests of their members. The next amendment is on page 35. Page 35, 20 capital A. This provision is actually in Annex 1 of the original ordinance. And these are requirements in relation to certain terms, and we think that they're important. That's why we moved them to the main, ordinance. The term said that the stipulate that it's kind of low. I'm also looking at 20A. I understand that these terms are already can be found in the existing ordinance. I'd like to ask whether or not Schedule 1 is also part of the principal ordinance. It's the schedule to the principal legislation. So it is a subsidiary legislation. I remember that Schedule 1 was also part of the principal legislation, except that the presentation is now changed. Okay? We were referring to 20A. Another requirement is that without the consent of the members of the scheme, you cannot change the interests of the members. The next amendment may be found on page 37. That is 20 capital B. In explaining the exemption provision, there was a similar provision. That is, in certain schemes, if they allow eligible anyone. Now, in order for the registrar to take enforcement action pursuant to this ordinance, we would deem that the scheme is still part of the registered scheme. But for the provision allowing other people to join the scheme will no longer be valid. And that requirement would only affect the scheme upon the enactment of the bill. In page 38, this is a textual amendment. Page 39, again another textual amendment, because we've already removed the existing interpretation. So we've here make a consequential amendment. That is page 40. We've added a new subsection. A trustee, which is about the responsibility of the trustee. That is, a trustee must, act with due diligence and should also act, for the interest of the scheme members. And these provisions are already in the under the MPF ordinance in respect of the responsibilities of trustees. So basically, this is to further enhance protection for the members. I think this is similar to the provisions under the MPF ordinance.
Here, the trustee, other than the statutory duty and the professional ethics on the part of the trustee, have you added anything about the qualifications and prerequisite of the trustee? No. Page 41. This is a consequential amendment. The triangle denotes a textual amendment. This is to simplify the provision. Page 42. The triangle is the main amendment. The employer has to provide a written statement to show that this is limited to eligible persons. The membership will be limited to eligible persons. Moving on now to page 44, the triangle there. The original provision provides that the registrar requires the report from auditors and actuaries. In 5A here, the registrar may take into account any report or certificate received under this section in performing any function under this ordinance. Page 45, the triangle. What applies to the exempted scheme, the registrar may, by written notice, require a person to give any of the information or documents relating to a registered scheme. The square there, we had a similar provision before. The registrar can specify certain documents like legal opinion or auditor's certificate. Moving on to page 46, this is an additional safeguard. There are important events that are reportable, like any requirements under Section 20 regarding the keeping of account, and also the compliance with the asset requirement. The administrator or the employer will need to notify the registrar as long as the information becomes available. (49) is a consequential amendment, and we are making this more specific to refer to it as a registered scheme. Page 52 is the next one. We've added the grounds for cancellation of registration. The triangle there is referring to the one moved from the annex. The assets cannot be used to make up for the misconduct. And 32, if there is no annual return filed, the registrar can cancel the registration. Page 53, 67 bracket 2 bracket GAB, that's about the annual statement. But that's applicable to the group companies, the employers of the group companies. This is in effect the same as previous requirements. We've also added another grounds for cancellation of registration in the square. If a person other than an eligible person becoming a member, I mean this will be included. Page 54, like what we did before, and that's proposal to cancel registration. The registrar can publish a notice in a way that the registrar considers appropriate. Previously, we had to have publication in the newspapers. Page 55. We referred to this in our PowerPoint presentation. In the original provision, the court may order the freezing of assets for cancellation of registration in order to enhance the safeguards. We advance the timing a little bit to the time when the registrar intends to issue the cancellation. The court may order freezing assets. That's to enhance the safeguards. Yes. A legal advisor. On page 55, it said the timing has been advanced to the time when the registrar intends to issue the cancellation. Freezing of assets can happen. When the cancellation is issued, the employer will not be notified. Is that right? Yes, that's right. In fact, we will notify. If we notify the employer before we go to the court, the assets might be removed. So we like to make it to synchronize the moves. When the registrar intends to issue the cancellation, the court then may order freezing the assets, because otherwise there may be a time gap for the employer to remove some of the assets. Yes, my question is, when the employer becomes aware of the withdrawal order, he would have received the order from the court about the freezing of assets. Is that right? Under the existing ordinance, Section 44, you would issue the withdrawal notice, and the employer can raise objection and can make representation. And you're moving the timing. Will the employer be given the chance to make representation? And he will face the court order to freeze the assets straight away. That's my concern. And there will not be any chance to defend himself, because it goes straight to the court order. There will be an additional safeguard that's in the triangle on page 55. There has to be sufficient evidence when an order is sought from the court. So the court has to be satisfied that the order is desirable without compromising anybody's interests. So there will be added protection for the employers. All right, no follow-up. Page 55. Right, the next one is page 56. Now, 45 to 47 are the same as the amendments to 42 to 43. Unless members have an objection, we skip this part. We skip ahead to section 48. Or page 60, section 49. Page 60, part 7 is about the winding up of Hong Kong domiciled schemes. What we do, we haven't changed the provision. We're changing the Occupational Retirement Scheme to scheme because some registered scheme, if they do not fulfill the criteria, they can no longer be called Occupational Retirement Scheme. So for winding up cases, this will not apply, so we have taken out the occupational retirement and just call it a scheme, so that the winding up provisions would continue to be applicable. So 49 to 60, they are for the same purpose. If members have no question, we can skip ahead to page 65, and that's about appeals. The triangle 3A. The chairman of the appeal board should be a person who is eligible for appointment as a judge of the High Court, or a former justice of appeal, or a former judge, or a former deputy judge. And that's similar to the provisions governing the financial institutions. The next amendment is page 67, the triangle there. As we explained before, if the registrar would like to add certain conditions, then that can become a ground for appeal, and we're making the consequential amendments there. Page 68. We are adding the inspection and investigation power. This is similar to the MPFA or other financial institutions' power of investigation and inspection. Page 69, 66B, general powers of inspection. An authorized person may, at any reasonable time during ordinary business hours, enter premises to carry out inspections. For special circumstances, there is a need to give a notice to the occupant of the premises. Page 70, the registrar or the authorized person can enter the premises to inspect any record found on the premises, or he can ask for assistance from the occupants of the premises. Mr. Leung. So with this inspection, you don't need any warrant, do you? You can just enter the premises. So how do you actually exercise this power? I fully appreciate that this doesn't exist in previous provisions. Why do you all of a sudden confer upon yourself such massive power? That these may be residential dwellings. I don't expect the schemes or the retirement protection schemes to be administered in residential dwellings. But my question is, why do you need so much power? Is it commensurate with the power under the MPFA ordinance? Well, we can only enter the non-residential premises. So it has to be commercial premises. And this power of inspection is exactly the same as that under the MPFA ordinance. So you don't need to give any advance notice. And you can just enter the premises without any notification. No, there is a need for notification. 66B 3 an authorized person must give the occupier of the premises reasonable notice. Reasonable notice, I mean, if you call up 30 minutes beforehand, is it reasonable notice? Or are you going to write to them and let them know about the inspection? I'm sure under the MPFA ordinance, you must have some experience to share with us. Yes, for also scheme, this is something new. We didn't used to have this power. For MPF, we do have a similar power. And prior to the visit, we would write to them and let them know in writing what we are intending to see, so that they would get the documents prepared, and that will smooth out the entire process, and we get access to all the information that we desire. Mr. Leung, under the MPF, would you conduct surprise visits? Well, surprise visits, there is no need for us to do so. So these inspections would be conducted with prior notice, and we would allow enough time to make preparation beforehand. All right, shall we press on? A legal advisor, please. Yes, also on 66B, I've noticed it on page 70, that's bracket 6. A person may exercise the power conferred by this section only if the person A is in possession of a warrant of authority issued by the registrar. That's a warrant. I can't see anywhere in the ordinance any provision that confers upon the registrar to issue such a warrant, and there is no mention of the registrar having to satisfy certain conditions for the warrant to be issued. So will these be addressed? Where do you derive the power from?
Now, who would like to respond? I think, when we go to page 97A, we've added the provision saying the registrar. We will explain it will provide for the authority of the registrar to issue warrants. So 80A is what it's the section about the registrar may actually authorize a person, may issue the warrant. Now you're talking about entering the premises of an office to get the evidence. So do you need to stipulate the conditions which the registrar has to comply with before issuing such a warrant? I noticed that for many provisions involving the issuance of warrants, there is a stipulation that the person who has the authority to issue such warrants must satisfy certain conditions first before issuing such a warrant. So that's my question. I think 70 bracket 6, the so-called warrant, means that sometimes the registrar may not conduct the investigation into the premises. He may appoint an accountant to do that. So the purpose here is to prove that the person has the authorization by the registrar, rather than saying the conditions under which he may enter the premises. So this is simply to identify, to verify the identity of the person who has the authority, who has been authorized by the registrar to conduct the investigation. Any further questions? If not, let's move on. We're now on to page 71, investigation. Now, registrar may investigate any matter if he has reasonable cause to believe that someone has breached the ordinance or something, circumstances which may prejudice the interests of the members. So the registrar may conduct investigation himself or in writing instruct someone to conduct the investigation. 66B is about the investigation power of the registrar. The registrar may, in writing, require the person to surrender the records stipulated in the notice, or require the person to answer questions put to him by the investigator. Page 73, 66E. We've added a provision that is someone who fails to. This is about the offences for not cooperating with the investigation. The penalty is provided for on page 74. That is, if a person commits an offence under subsection 1, is liable on summary conviction to a fine at level 5. If there's an intention to defraud, there will be it will attract a level 6 fine and imprisonment for 6 months. 66F is about offences for giving false or misleading information. Subsection 4 and 5 on page 74. Here we've added the corresponding penalty, that is fine at level 6 or imprisonment for 6 months, or for subsection 5, person who commits an offence under subsection 2 would be level 6 fine or 6 months imprisonment. Page 76, 66G. The court may issue an order in respect of so anyone who has not complied with the investigation requirement. So the court may order the person to comply with requirements and punish that person. 66H, please hold. Our legal advisor has a question. You're saying that if someone failed to comply with the investigation requirements under 66D, that would be a criminal offense. In 66G, you say that for non-compliance of the investigation requirement, there will be an inquiry in the court. So for these two different methods of handling such non-compliance, under what conditions would you decide to go for a criminal prosecution, and under what circumstances would you go opt for an inquiry in court? Now 66D, now the legal advisor was asking that if there's non-compliance, there will be a penalty. But if the registrar needs to has this requirement, he may invoke 66G. Request that is through the court, he will order that person to surrender such information. 66H. For 66F and G, there are provisions for penalties. So we don't want to have a double jeopardy. So if somebody breaches 66G and F, and if has already been punished there, then he cannot be punished a second time under 66G. So we actually deal with the duplication here. Now, to obtain the information, then we may need to invoke 66G. That is, the registrar may apply to the court for a hearing. So we were on to 66H. We may now turn to page 77. So this is 66I, use of incriminating evidence in proceedings. That is, if the investigator required a person to answer any questions, then he has to remind the person that if he knows that the information he provides will be self-incriminating for himself, and if he makes such a claim, then such information or responses will not be used in the criminal proceedings and used against him, except that for non-compliance with the investigation requirement or under 3, that is making a false statement upon oath. Next, we're on to page 79. Section 67, special provisions for schemes covering groups of companies. Many provisions actually correspond to some previous ordinance. Page 81. The amendment on this page is a consequential amendment. We've added certain provisions, and therefore, but this is only a reference. Page 82. Bracket D, we are amending the original bracket GA. We've added, for an employer who, so what we're saying is that a scheme, so I think this is similar to the one we've talked about before. 83, bracket GAB, the employer is required to make a written statement. Page 84. The first one is a textual amendment, and the triangle, Mr. Kenneth Leung. For the textual amendment, reasonable cause is now amended to become reasonable excuse. Reasonable excuse is this the same term used in the MPF ordinance? Is the term reasonable excuse also used in the MPF ordinance? Perhaps the DFJ could answer the question. Well, I may not be able to answer the question right now. We may need to go back and check. But here we've used reasonable excuse instead, because it would provide for a better description. Reasonable cause refer to some reasons. So therefore, we are taking the opportunity here to make the amendment. You say this is a more appropriate term. Of course, this is a matter of opinion. Are there other ordinances where you've made a similar amendment? So have you made similar amendments to the terminologies in other ordinances? We've not amended an entire ordinance using this term. But this ordinance is rather old. It used the word excuse, which is not so appropriate because we would like to use more modern, terminology, and the connotation for the term cause is it's excuse. I'd like to remind the law draftsman that if you want to modernize your terminologies, you should be consistent. I don't want you to adopt this approach in respect of this bill, and another law colleague drafting another piece of ordinance will use other terminologies. So if you have such a decision to modernize lexicon, I think it would be best that you be consistent. So either you stick to, or such as taking the reasonable excuse. Of course, you have very stringent drafting rules to follow, but regarding the use of terminologies, I hope that you could have some detailed guidelines internally within your division. Thank you. We'll certainly go back and relay that for the consideration of the Secretary for Justice. So the next one is about failure to submit declarations. Next, we are on to page 88. We stipulate here that the transfer has to be effected pursuant to an agreement, and that it should involve the same member. Bracket 2B is in respect of overseas schemes where you have transfer in and transfer out of interest. And here we've added the requirement that the member that is the transfer is made directly from the transferring scheme to the receiving scheme. We want to ensure that all the benefits are transferred pursuant to an employment relationship. Page 90. 70B, transfer of benefits. So this is actually to regulate the transfer in between two also schemes. MPF, assets cannot be transferred to also schemes. For also schemes, they could be transferred into the MPF scheme, depending on how the trustee deed is drafted. Is there any provision saying that the accrued benefits under the also scheme cannot be transferred to an MPF scheme?
咁樣入
Well, this is done through voluntary contribution, and this is not direct transfer per se. Understood? Thank you. Moving on to page 90, 75, immunity. We are making it specific that this applies to the registrar, director of the registrar, an employee, and so on. Page 91, disclosure by the registrar. And we are making this commensurate with the provisions for the financial institutions that the seeking the disclosure registrar is for seeking advice from barrister or solicitor, or the information has been available to the public, and the registrar can also make available information to the SJ. Page 92. If the interest of the members is prejudiced, or if it is in public interest, then the information can be made available to the insurance authority and the Hong Kong MA and so on. Legal advisor, please. EB 3. The disclosure enables the performance of a function conferred by law. Does it mean the registrar's power, or what? Registrar's function? Well, that's the receiving institution, like the insurance authority and the monetary authority. When they are performing the function, they require the information from the registrar. Bracket H, that's in the square, next to the square. If an exemption has been cancelled or registration has been cancelled, then there can be disclosure of any material facts of the case, and that's intended to enhance the transparency. Page 93, the triangle there. Earlier one, capital A. The registrar can make disclosure to the Secretary for Justice, and he has to make sure that this disclosure has to do with the interests of the members and the public interest. On to page 94. It's about the general offences. Now the square there, we are rationalizing the penalty to make it commensurate with the other provisions. Page 95, clause 79A, offences of obstructing performance of functions. If anyone is obstructing the performance of functions by the registrar, there will be a penalty, level 5 fine and imprisonment for 6 months. 79 capital B is the prosecution deadline for summary offences. Now we're referring to page 96A, the end of 3 years after the date on which the offence is committed, or the end of 6 months after the date on which the offence is discovered, whichever is earlier. 79C is about the proof of reasonable excuse or lawful authority. In proceedings for an offence under this ordinance, the defendant is to be taken to have established that the defendant had a reasonable excuse or lawful authority for the contravention in question. Page 97, 80, capital A, the registrar may appoint an authorized person to perform the functions under this ordinance. Page 98, clause 85, there is a deeming provision there. Here, it is intended to make sure that the non-compliant schemes may have emitted people other than the eligible person, and if a scheme is no longer a registered or exempt scheme under this ordinance, we will still deem that the scheme will still be governed by the relevant provisions of the ordinance. 86 is a transitional provision. The amendment ordinance will come into effect on a day by notice in the Gazette. Before commencement, if application comes through, it will be dealt with under the existing ordinance, and there is a need for the employers to submit annual return. We would, these new requirements would only come into effect for the next financial year. That would allow more time for compliance on the part of the employers. And then Scheduled 1, documents required for registration, and that include the statements from auditors and lawyers. Now for lawyers, we specify that they would have to state that this is only applicable to eligible persons. Page 101 for the auditor's statement has to say that this is only applicable to eligible persons. Mr. Kenneth Leung, Chairman, can you be more specific about the lawyer's statement and the accountant's statement? What's the difference between the two? Second, I'm not sure whether this is a statutory statement or what statement is it. Now for these lawyers and accountant statements, if it is subsequently found that there are errors, now some may be negligent errors, some may be deliberate errors, what legal consequences would there be? Perhaps the MPFA can supplement later. Now for lawyers' statement, it is about the provisions of the scheme, whether it is limited to the eligible person. Now for the accountant's statement, it would cover the financial transaction. There will be a statement to show that this is limited to the eligible persons. Chairman, for these two statements, it is an annual thing, isn't it? The accountant statement, there is a lot of transactions throughout the year, and do you need to have an annual statement for the accountants? Schedule 1 is covering the documents to be submitted during the application. So the accountant's statement will have to be covering the situation 3 months prior to the application. Mr. Leung, there is an annual return. Does the annual return have to be signed by the accountants? No, not for the annual return. That's only for the employers. That the legal liability, if it is a false declaration, we do have the penalty there. So the two statements would be a kind of statement under the oath and declaration ordinance, or is it something else? Is it statutory, or how does it work? I'd like to find out more about it. I'm trying to find out what the professionals would have the legal liability. This is not a statutory statement, but under the ordinance, if an accountant has made a false declaration, then the registrar can refer the case to the relevant professional body. Yes, please carry on. 103, 2, capital A, a statement by the applicant himself. And the following is consequential amendment, requirements of section 25, 2 and 5, and all the requirements are to be observed by the trustees. Page 104. The requirements are similar to part 1 in terms of documents, but this is in relation to the pooling agreement. Page 110, we have taken out the definition there from the interpretation. This is a consequential amendment. Page 111, similarly, the existing scheme refers to those before 1993. This is a consequential amendment. The next one is on page 115, documents to be authenticated. Again, this is a consequential amendment. The auditor's statements are put under this particular schedule. Page 116, again, in the light of the new requirements, the relevant provisions are put under the schedule and to fulfill all the requirements regarding documents to be authenticated. So much for the clause-by-clause scrutiny. I welcome any questions. We're done with the clause-by-clause scrutiny. I'm grateful to the officials for addressing the questions, and in particular, I must give a pat on the back of Mr. Leung for sticking with us till the end. Chairman, I'm wondering whether you need to have any written submissions from the professional bodies. Yes, indeed. I'm going to ask members whether there is a need for any public hearing. I don't have any strong views regarding deputations. This bill is about the professional bodies, the service providers, and they're more interested in going into details about this bill. Perhaps we can write to the relevant bodies, maybe the chambers, the professional bodies, or the service providers, or certain institutions that might be interested, and the Secretariat or the legal advisor might have a think about it and see what institutions should be covered and let them know about this bill and solicit their views in writing. I think there is a difference between public hearing and just soliciting their views, because we can hear their views straight from the horse's mouth. Well, either way is fine by me. I mean, it's down to me here. I think we have to take a decision. I mean, either way is fine by me. Chairman, the ball is in your court.
Mr. Leung, could we send a letter to all the members of the Bills Committee before we decide? Okay? I also like to ask the administration this question. When are you going to resume the second reading of the bill? Chairman, I think we need to go back and think about it. We will inform the Bills Committee as to when we're going to resume the second reading. We also have certain, textual amendments and CSAs, which we will circulate to members after the meeting. Okay, thank you, all the officials, for your detailed explanation. Thank you very much. Any other business? We don't have any other business, so the meeting is adjourned. Thank you.